SJC-12592, Commonwealth v. Donnie Agogo.
Mr. Freites.
Good morning. In Commonwealth versus Agogo, Mr. Agogo was seen outside of a building.
Could you lift your voice a little?
Yes. In Commonwealth versus Agogo, Mr. Agogo was seen outside of a building, walking in and out of that building. It was about 5 or 6 minute intervals over a 20 to 25 minute time. The police officer observing this activity noted that in his training experience, when people are going in and out of a building in a high crime area, it could indicate that there was a drug stash and a person may be selling drugs out of that apartment. The individual, Mr. Agogo, disappeared from sight on the occasions that he went outside of the drug house and then returned. Given his training experience,
How many times did he do that in this case?
I'm sorry?
How many times did that
5 or
happen?
6 times in 20 to 25 minutes. And in each time he disappeared from around the corner, and the detectives could not see his behavior where it took place outside of that area. On at least one occasion, before the arrival of Mr. Foster, the co-defendant in this matter, he went around, Mr. Agogo met with somebody and went around the corner of a side street. The police surmised that was probably a drug transaction. Then the next person to come along was Mr. Foster. There was a short conversation, and they went around to Division Street, a small alleyway around the corner from the street they were on, and police followed. A drug transaction took place within police view. They couldn't see what was exchanged, but clearly they observed the drug transaction, and they approached both defendants. Mr. Foster was dealt with by Mr. Torres, Detective Torres. Lieutenant Detective Betts engaged Mr. Agogo. Mr. Foster was fairly compliant, not completely, but fairly. And after he was dispatched by Detective Torres looked about 10 feet away from him to Mr. Agogo and Lieutenant Detective Betts. Mr. Agogo was giving Lieutenant Detective Betts a very hard time. He was not compliant with his orders. He had taken a bladed stance. Mr. Torres's training experience seemed to suggest that a bladed stance was a fighting stance. He noted to the court that he was afraid for his own personal safety. This would suggest something other than hiding something on his person. There was no nexus between the groin area and that detective's training experience. On more than one occasion, the ADA handling the matter tried to elicit testimony from Mr. Torres that would indicate that there was something specifically going on with the defendant's groin area. They call it jocking, they call it cheeking, something to that effect. And all of the case laws in Massachusetts, there is no case law that supports a strip search without some sort of nexus between that officer's...
Can I take you back to?
I'm sorry?
Can I take you back to the observations of Mr. Agogo and the findings of the motion judge? Do you say that he actually found that Mr. Agogo was re-upping, or do you? It seemed to me that the judge just noted that under the police officer's training and experience, that could be what he was doing.
I believe that you have a clear-cut case here. The transcript and the judge's findings clearly indicate he was going in and out of the building 5 to 6 times over the course of 20 to 25 minutes. He was engaging in drug dealing transactions. So what it is for this court is that a fair inference? And you have Commonwealth v. Johnson, where the gentleman was doing something similar from a drug stash around the corner. I respectfully suggest to the court that there's no other reasonable inference that could be taken from those facts and that behavior.
Couldn't he have been returning money?
Oh, sure, Judge. But given the facts at hand, you cannot exclude the other possibility. Yes, that's true. There was also a woman seen with him. That woman disappeared at some point, but at least on 2 different times he was going back and forth. She was present and also entered the building with her, which suggests the drugs could have been on her.
Can you address the issue, the standard of probable cause? Is it different for a strip search than it is for any other kind of search? Is there any kind of difference in the language or the standard?
In Commonwealth v. Thomas, this court departed from the federal standard and required probable cause. In that matter, the defendant requested this court adopt a particularized high degree of probable cause, something similar to what is required for a warrant for a body cavity search. This court rejected that and went with a typical probable cause finding. In the dissenting opinion in the first paragraph, they say that Commonwealth v. Thomas indicates a particularized probable cause. What I think they mean by that is Commonwealth v. Thomas plus the fact that this court's never issued any strip search case that didn't have some sort of particularized indication that a defendant was jockeying or cheeking drugs. So I think that's where they get that from.
There has to be something else beside the probable cause. So every time the police have probable cause of a drug deal, and then they go to the would-be seller, and they don't find drugs, they could do a strip search. So you have to have a plus, like you're referring to, don't you?
Yes, Judge, and there's case law to support that. In Amato, at least in one other case, there is here we have indications of drug dealing with no indications of jockeying or cheeking. In other cases, we've had indications of jockeying and cheeking with no drug offenses.
So Amato was wrongly decided.
I'm sorry?
Was Amato wrongly decided?
No, I don't think it was.
You cite the dissent in Amato, right?
Excuse me?
I thought you cited the dissent in Amato.
No, the dissent in Agogo, appeals court case.
Thomas, you mean?
In that, so my reading of this together is that in order to find probable cause of strip search, there must be indications of a drug crime afoot, and there must be some sort of nexus between the groin area and the officer's training experience.
So when you say a nexus between the groin area and the officer's training and experience, what would that look like?
Any indication that there was something going on in the defendant's groin area or cheeking drugs. That if you lack that, a person's training experience applied to facts that don't direct themselves to either a drug crime or the jockeying is the definition of a hunch.
Okay, so which one are you suggesting here? That there's no training or experience, or that there's no jockeying, or no?
There was training experience.
There was training, or there wasn't?
In fact, we have two separate factual basis here. One, he's going in and out of that apartment 5 or 6 times over the course of 20 and 25 minutes. And I think the fair inference is only that he could be dealing drugs with a stash house. Then on the other side of this, we have his pre-arrest behavior where he's hostile. And I don't believe these two factual bases stand on equal footing. It's a clear inference that he's going in and out of that house. The question is why, and that's for this court to decide. On the other side, we have a contention here. Is this a fighting stance, or is this an attempt to evade a search of his person? On more than one occasion, the ADA tried to elicit testimony that suggested there was something going on with the defendant's groin area, and each time, Detective Torres backed away from that determination, did not offer those facts. At the end of the motion to suppress, he says, well, yes, we strip searched him because that's where he was trying to push away from us. That was a conclusion unsupported by the testimony that preceded it. So it's one of those things where we have other case law that says if you have multiple different possible inferences, it's up to the training experience of that officer to single out one of them. Well, I think that depends on the nature of those inferences. If you have major inference, if you have 2 different possibilities, both supported by case law, then you may have a situation where it rises to the point where if you have an equal amount of evidence in favor of 2 separate inferences, you fail to prove either. My mind goes to Commonwealth v. Wood in 1981, a possession with intent to distribute case. And here, both back at the jail and also at the beginning, the jail, he's protesting. Yes, the detective said, in my training experience, that protesting would suggest he's hiding drugs. But in our case law, we also say that behavior, that strip search is humiliating, demeaning, terrifying. And if that was just one factor among many, I would agree with the court. But it's well-rooted in our case law and suggests it has standing side by side.
But so if they had pat frisked him and felt something during the pat frisk, you would agree that would give rise to probable cause?
If that were the case, I wouldn't be here right now.
Okay.
And if they had...
Which was a motto.
In Amato, they had jockeying, but they had no drug crime. Here, we have a drug crime with no jockeying.
And if they had seen a bag protruding from his groin area?
Well, in Vic, it wasn't really a strip search because he just reached right down and grabbed it. Nothing was exposed. And if they had seen something like that, I don't think I'd be here either, Judge.
And if they had seen him go to his groin before he did the transaction?
Not at all. And we have another case where somebody was handcuffed and reaching down his rear. Same thing. If you have a good indication that something's going on down there, I don't really think you can argue with it.
The mere fact that an officer opines that the person is re-upping and they don't find drugs is not enough.
I'm sorry?
The mere fact that an officer says that someone's re-upping, and there's strong evidence of that, when they search the person and they don't find anything on their person, that, in your opinion, does not give rise to probable cause for a strip search.
I think it cancels probable cause. I think it cancels the idea that on the opposing...
And Justice Lowy's question he asked you was, if we were to say this is okay, we would sanction a strip search in every case where they don't find drugs on the person's person or money.
Absolutely, Judge. Also, that goes for the post-arrest behavior of Mr. Agogo back at the jailhouse when it's same thing. In that case, my mind goes to the idea of canine officers with dogs that are trained to sniff out drugs. All they got to do is yank on the leash. Same thing here.
Yeah, and also, so your point is that a lot of people, when they're told they're going to be strip searched, they're going to understandably resist.
Absolutely.
And if that factor can be considered, you sort of can create your own constitutional justification. And what I'm wondering is, I mean, I think there's perhaps an analogy to Commonwealth versus Stout, that you can't take into account flight unless there's already constitutional justification for the pursuit. Here, just resisting a strip search, if that were enough for a strip search, you'd create your own justification.
Given that principle was embraced by the dissenting opinion in Commonwealth v. Warren, a majority opinion distinguished that case by saying they already had probable cause of strip search before they went there. I highly disagree with that. If you do not have probable cause or reasonable suspicion, depending on what standard you're arguing and what case you're arguing, allowing that post-arrest behavior, flight, for instance, it allows the detective to trigger the behavior he's looking for. If there's no further questions, I'll waive my time.
Okay, thank you.
Thank you very much, Judge.
Ms. Teo, good morning.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Amanda Teo for the Commonwealth. I'm asking this Court to vacate the motion judge's order, granting in part the defendant's motion to suppress. To address this Court's concern about probable cause to strip search here I would say there are 5 factors that affected the officer's probable cause calculus. The first is that the defendant went around the corner. They had seen the defendant soliciting customers and conducting what they suspected to be multiple drug transactions before Mr. Foster even arrived. They also saw the defendant going around the corner with Mr. Foster without going inside the building and knowing ahead of time how much Mr. Foster would purchase. That gave them a reasonable inference, a suspicion at that point, that the defendant had additional contraband on his body.
Is this still point one?
This is point 1, Your Honor.
I don't follow the logic of that. Can you explain that? Because we see him going back and forth 5 times into the building. We also have this Torres' testimony that he thinks that's evidence of a stash in there, right? Right?
Correct, Your
So
Honor.
that he goes back each time to hit the stash. Why would we conclude that he has more than what he's just sold this time? You lost me on that last point.
Thank you, Your Honor. Let me first point out that there's a factual lacuna here, and that is in the judge's factual finding, he found that Officer Torres is aware that it's common practice for persons engaged in street-level drug transactions to not have a drug stash on their person, but rather to retrieve a small quantity of drugs, not just one packet of drugs from a location, sell the drugs, and then return to the stash location to retrieve another small quantity of drugs to sell. He also found, the judge also found that on several occasions, the defendant entered the building, remained inside and out of view for 30 seconds, and then came back outside to the sidewalk. The motion judge did not explicitly find that this particular defendant was did in fact have a stash inside the building. Although I submit that it is a reasonable inference for the officers to draw the conclusion that he might have had a small quantity of contraband on his body to sell. I think that just makes sense in the context of a street-level drug transaction. And that leads me back to your question, Justice Kafker, which is that if police officers see someone outside of a building soliciting multiple customers for drug transactions and then go around the corner with one customer, I think it's reasonable for them to infer that that person, that dealer, would have a small quantity of their drugs in their body that would allow them to meet whatever demand was of the multiple customers they were soliciting.
Say that they knew Foster was buying a certain amount?
No, he did not know the amount that Mr. Foster was buying, and I think that's why I place emphasis on that. He didn't go inside the building after, he didn't go inside the building before making contact with Mr. Foster, and he didn't go inside the building after making contact with Mr. Foster.
How is that not to raise the Justice Lowy concern, license to strip search every drug dealer when there's a stash involved?
Because if that was the only factor we had here,
Cut you off on factor one. You're going to give us 4 others?
I am going to give you 4 others. And I think it really is the combination of factors here together that provide probable cause for this search. The second factor here is that Mr. Foster only bought one bag, and that bag was valued at about $20, and the defendant only had $20 on his body when the officers completed the search at the scene. So again, that's a very minimal amount, and they could draw a reasonable inference that a street-level dealer would have more than that on their
Isn't it
body.
also reasonable to think he just sold him a 20?
I'm sorry, Your Honor.
Isn't it just reasonable to think he just sold him a 20 for a 20, and then he's going to re-up?
That is a possible inference,
Right.
but again, as this court well knows, I am going to rely on the teaching from this court that there may be innocent explanations and there may be alternative explanations, but it's really a panoply of what the police observe at the scene that allows them to determine probable cause. The third thing is that the officer did know, based on his training and experience, that the groin area is a common location where drug dealers would hide their stash. And then I think the fourth and fifth factors in combination are important here. And I want to make sure I return to Justice Lowy's question about flight. But here, let me just articulate 4 and 5. 4 is that the defendant was protesting the search on the scene. He had bladed himself. He had taken a fighting stance. He was pulling away. And here the motion judge specifically credited that he was taking this fighting stance in a specific attempt to prevent a search of his person. And that is important. Even though the judge did not find that he was specifically trying to insulate his groin area from the search, which is what the officer ultimately testified to, he did say he was trying to evade a search of his person, period. And that animated protest is really...
Excuse me, was that before or after the $20 was found on him?
That was before the $20 was found on him.
That was before, that was really at the very beginning. He didn't want to have any search of anything.
Correct, Your Honor.
Okay.
And I would suggest that that is an outsized reaction to a $20 bill on his body. But the second is that then he continued to protest vehemently the search when the officers informed him at the station that they were going to conduct a strip search of him. And that's even after the $20 had been found. And so that, again, leads the officers to a reasonable inference that he had additional contraband on his body that he did not want them to find.
So your first factor is that the defendant was soliciting customers and had been putting drugs somewhere in the house, perhaps, or going back and forth from this place. What's the second one again?
The first factor is that he is soliciting customers and going around the corner with Mr. Foster without going anywhere.
Okay.
The second is that Mr. Foster only bought one bag valued at $20, and the defendant only had $20 on his person.
That's what I don't understand, how that leads you to conclude You're just saying it's an equal inference, or even if it's not equal, it's an alternative theory that he was out of drugs, or it's an equally alternative theory that he had more drugs on his person?
Correct, Your Honor, and based on the officer's training experience and what they had seen during these 30 minutes of surveillance of Mr. Agogo before Mr. Foster arrived, they could draw the inference that meant he had additional drugs on his
So
person.
if he had $40, they couldn't draw that inference? I'm trying to understand, or is it anything under 1,000? I'm just, it's because it's 20?
Well, it's because Mr. Foster had a very small amount of drugs, just a $20 bag, and they had, in fact, seen him, Mr. Agogo, soliciting other customers and conducting other drug deals as well outside of the building.
At the time of Mr. Foster?
Correct, Your Honor. They were in their surveillance position.
I guess what I'm saying is, were there other customers beside Mr. Foster who he was soliciting?
Yes, Your Honor.
At the same time that he was soliciting Mr. Foster?
I don't think it's at the same time. They were at their surveillance position for 20 to 25 minutes before Mr. Foster arrived, and they had seen him soliciting customers, and the motion judge's findings was that he had gone around the corner with other customers, or he had engaged in that pattern of behavior before Mr. Foster arrived.
Did he go around the corner with Mr. Foster?
He did. He did.
Okay, so I'm having trouble too with why the $20 bill found on him indicates anything.
I think I more want to place the emphasis on the fact that Mr. Foster only had one small bag, which links to my first factor.
Gotten that from the stash that he went around the corner to get?
I'm sorry, the stash would have been inside the building, I guess, by the inference here would be that the stash was inside the building and that he was conducting the drug sales around the corner from where he was soliciting customers.
Out of his, where did the drugs come from that he sold to Mr. Foster?
I think the officer surmised that it was coming from his body, that he had put those drugs somewhere on his body.
So that he was going into the building and getting the drugs out of his pants?
He may have been doing that. He might have been depositing the money from his previous drug sales. He might have been, but the testimony from the officer was that in his common experience, it would be that dealers would put a small quantity of drugs on their body, then conduct the drug transactions, and then when they ran out, they would go back inside the body, into the building to
I
re-up.
get why the first four factors justified a search, which yielded the $20 bill. But I can't I don't get why protesting a strip search means that you should be strip searched. I would imagine that anyone who's told that they are now going to be strip searched would protest. So I don't get why that's a reason to, that must mean you've got something on you.
No, Your Honor, I hear your concern, and I think if that was the only factor that I had here, I would not be standing before you making this argument.
But how does this change, I mean, how would it be different from any drug dealer, any person that they assumed was dealing drugs? They found a $20 bill on them, and then they protest the strip search. That person would always be strip searched, based on what you're saying.
No, Your Honor, because here, again, I do want to place emphasis that it's really the entire choreography of the events that they're witnessing. So it's not just that they find a $20 bill on the dealer and that he protested a search. It's that they have witnessed him conducting multiple drug transactions. They don't see him going back inside the building to re-up before Mr. Foster arrives. So ostensibly, he has something on his body when the buyer comes. It's also that he protests on the scene in an outsized way, disproportionate to the $20 that is on his body, and that protest becomes a meaningful pattern when he continues to protest at the station. And I understand, Your Honor, that I think this court is. I understand this court's concern that strip searches are intrusive. They are potentially humiliating. But as the Supreme Court in Wolfish, and as this court in multiple cases has said, the the invasion of privacy must also be balanced against the need for the search. And here, what were the officers to do? What was the better alternative? Police officers have seen this choreography play out. They have what they believe is probable cause that this person is secreting additional drugs in their body. They have now brought this person inside the station. And the police have a legitimate concern, not only in preserving the evidence, but in also ensuring that dangerous substances, such as narcotics, do not enter the station house where they present a risk to the
Under that
defendant.
theory, why shouldn't anybody being brought into a police station and put into a lockup be strip searched?
Because I'm not saying that that in and of itself justifies the search, and I'm not
But
saying that
wouldn't it be good safety policy for the lockups in the police stations?
I do. I do, Your Honor. But I recognize that there are there is case law that suggests that I may be too protective here. But I'm not suggesting that this court say that anytime somebody comes into the police station after conducting a narcotics deal, that they should be strip searched. What I'm saying is the problem.
Aren't you saying anytime someone is arrested for a narcotics offense where they protest the police frisking them? Because in certain ways, this is like a case where it's less likely to be on him than normal, right? He's constantly re-upping, so he doesn't carry a lot on him, right? 5 times he's gone back and forth to re-up. And the idea that he's going to put it in his jock strap each time when he goes in and out, isn't he going out of a public building? What's this building?
It's an apartment building.
So what you're saying is we have to assume that he goes into the building, re-ups all the time, and sticks it in this secretive place each time? So he's going to put things in his pants each time in the building, and then, but it seems like all we're really left with is the protest, right?
No, Your Honor, and I do want to emphasize.
Let me just, I mean, normally we've got a lot of drug transactions going on in the streets without anyone re-upping, so they're carrying it somewhere on their body enough to keep transacting. Here we have the suggestion that the person's not carrying very much, right? And then we also, we really have this, he's very unhappy about being touched. I get that.
Yeah, Your Honor, and let me just return to try to emphasize my points 1 and 2, which is that first of all, the factual finding that was credited by the motion judge was that drug dealers, in the officer's common experience, would keep small quantities of drugs. Not that they would only keep one bag, so that they would never, ever, ever, ever have any drugs on their body. I think that was actually the dispute in the footnote between the majority and the dissenting opinion in the appeals court.
Isn't there a difference between saying that Officer so-and-so, in Officer so-and-so's training and experience, it's common to do this, versus I find that this defendant did this?
Yes, Your Honor, I think there is a difference.
Or he didn't make the finding that the defendant did anything in particular except for go in and out of the building.
Correct, Your Honor. There is a factual lacuna there. So it could be interpreted in both ways. But I would suggest, Your Honor, that these 5 factors, they really did, it wasn't just that they arrested someone.
Factor, I'm sorry, I missed that.
The 5th factor was the continued protest at the station. So it wasn't just that they found $20, that they saw a drug deal, that this defendant protested. It was in concert with the fact that they had surveyed him for a period of time, understood the pattern of his behavior and the choreography of the drug deal and the transactions that led them to have probable cause that he was secreting additional contraband on his body.
So they saw him engage in 2 drug deals, correct?
I want to be
They
careful.
saw the transaction.
They saw this specific transaction with Mr. Foster, and I believe the motion judge's finding, and I don't want to misquote him, is that he observed the defendant attempt to initiate conversations with some of the pedestrians passing by. On one occasion, Torres observed the defendant walk with one of the pedestrians he had encountered around the corner. he was out of view for 5 to 10 minutes in the return.
Oh, I see. So they didn't see the first transaction, they saw only the second exchange.
Correct. They saw what inferentially was a drug transaction previous to Mr. Foster arriving.
But when they were watching this particular transaction, they did not see him go to his groin.
Correct, Your Honor. And they did not see him going inside the building or in his
By
groin.
your theory, they would have to assume that he had $20 worth of cocaine in his hand and that he kept that in his hand, but that he had more in his crotch in case it was a more than $20 sale. That's what we are to infer, that you carry a 20, but you keep more in your crotch?
No, Your Honor. The police were in their surveillance position. Mr. Foster and Mr. Agogo disappeared around a corner for about a minute before the police officers actually arrived to witness the hand-to-hand. So what Mr. Foster and Mr. Agogo were doing and where their hands were between that minute when they started their vehicle and went around the corner, and the two men go around the corner, that is not in the judge's factual findings.
Okay. Now, by the way, is there any, apart from what the officer said at the time of the search, is there any testimony about keeping drugs in your crotch in terms of what they were observing? Because I had thought that they were using his re-upping as evidence of reasonable suspicion for the stop.
There was no additional evidence other than there was testimony on page 25 of the transcript in which the officer testified that he thought the crotch area warranted further attention because that's where Mr. Agogo was distancing himself from us during the encounter. But to be fair, that was not explicitly credited by the motion judge. I think it is consistent with his findings under Jones-Pennell, but I won't belabor that point. But I do think that all 5 factors have to be considered together as a package, and I would urge this court, when considering those factors, to think about what this court would have the officers do, given their legitimate concern about additional drugs coming into the police station.
Counsel, before you end, can you reconcile that with Commonwealth versus Amato?
I can, Your Honor. Obviously, with Amato, I would have concluded with Chief Justice Gantz that there was probable cause there to conduct a strip search. In Amato, however, they did actually do the pat frisk and they felt a hard object in the groin area. There had been no probable cause that there was a drug transaction, according to the majority. I would have argued that when you feel a hard object secreted in a groin area, it is enough to determine there's probable cause for a drug arrest and thus for that strip search. Here, I have to acknowledge that there is no additional groping or more intrusive pat-down that would have revealed the existence of a hard object in the groin of this particular defendant. And I think...
I don't think the police refer to a pat frisk which touches the groin as groping, but I take your point.
I say that only to make clear that the alternative to what happened here might not be that pleasant either, Your Honors.
All right, thank you.
If there are no further questions, I'd rest my brief.
We'll take our morning break.
Thank you.
All right.